afternoon, everyone. Thank you for joining us today for today's online talk, which will be starting shortly. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
All right, hope you guys enjoyed that video. Welcome, everybody. Thank you for joining us for today's online talk titled The One-on-One on Friendly Loans. My name is Sohaimi. I'm a senior associate with Mohd and Associates, and I will be your moderator for today's session. Before we start today's talk, allow me to introduce the firm and what we do. Mohd and Associates is a mid-sized law firm that was founded in 1985 by Datuk Mohd. Our able team today comprises 29 lawyers, and a support team of 30. Datuk Ma is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small-medium enterprises, family business, and individuals. We are a full-service law firm with a corporate department, the dispute resolution department, including litigation, education, and arbitration, a dedicated employment team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of MWKA's online talk series. By way of background, we have been organizing monthly launch talks at our office since 2013, some of which were broadcasted live. But with COVID-19, we moved online in order to continue our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Allow me to introduce our speakers for today. First is Hannah Patrick, our senior legal associate practicing in the areas of general litigation, construction law, administration of estates, and debt recovery. She was admitted to the High Court in Malaya in 2012 and admitted to the High Court in Sabah and Sarawak in 2017. Our other speaker is Jeremy Balang, who is an associate practicing in the areas of medical law, personal injury, debt recovery, and general litigation. He was admitted to the Malaysian Bar in 2018. These are the top points which our speakers will be covering, including legality of friendly loans, imposing interest, friendly loan agreements, and security in other matters. With all that said, I invite our first speaker to take the floor.
Thank you, Anis, for the introduction. I'll now take over on the slides. I thank Anis for the introduction earlier. As mentioned, I am Jeremy. I'm one of the lawyers here in Mohd, and today, together with my colleague Hannah, we will be talking about friendly loans and friendly loan agreements in general. I'll start with this. The concept of a friendly loan in and of itself. It's extremely straightforward. There's no great mystery behind the language. It's one of the most common transactions in society, and it's also one of the most common transactions taken for granted. Why do I say this? A most basic friendly loan would be, say, if my friend James were to approach me, he says, Jeremy, I would like to borrow 10,000 ringgit. He doesn't tell me why. He says he can pay me back in 6 months. I agree. I say, no problem. I transfer him the money and I don't ask any other questions. 6 months later, I ask him to repay back, and my friend James tells me, or in that instance, either my friend James doesn't want to pay or he doesn't respond to me. In which case, the things that we take for granted when it comes to friendly loans come into play. In this talk, we'll discuss various topics relevant to the issue of friendly loans. We'll talk about the legality of a friendly loan. We'll talk about whether or not interest can be imposed and what kind of rates can be imposed. I will address the first half of it, whereas my colleague Hannah will be addressing the second half. In Tan I Teck and Tan Su Che, the reported case, which is on the screen right now, the judge of the Court of Appeal at the time had described a friendly loan as follows. A friendly loan is opposed to the normal borrowing from a moneylender or financial institution. A friendly loan is a loan between two persons based on trust. When I mentioned earlier about the things taken most for granted, one of the things most taken for granted when it comes to friendly loans is the issue of putting it in writing. So that's one of the things we'll discuss today. Let's look at some classic examples that have been adjudicated by the courts when it comes to friendly loans. In this particular case, Tan I Teck, the plaintiff, which is in this case Tang, T-A-N-G, agreed to grant a friendly loan to the defendant in the sum of 1 million ringgit, give or take. In this case, there was no written agreement. 2 years passed and no repayment of the loan was made despite requests. When sued, the defendant denied that it was a friendly loan and that the plaintiff and him were even friends. Tang sued, and the High Court allowed his claim. Tan, the one who borrowed the money and who said that he and Tang were not even friends, appealed the High Court's decision to the Court of Appeal. The Court of Appeal dismissed that appeal, and amongst its findings, it found that Tan, T-A-N, was trying to avoid paying the loan back to the plaintiff. Now, this case, we will explore it in detail later, but plainly and simply, this is a case where it proves that it simply shows the importance of having a written agreement. Let's talk about a different example. In Lim Chu Hao versus Simpson Wong. Here, Wong was the first plaintiff in the Sessions Court, and he agreed to loan to Lim the sum of 140,000. Lim later denied that it was a friendly loan and that it was in fact for something else. He suggested that it was a repayment of a previous advancement by Lim. Now, Wong, like many friendly loan agreement parties out there, he did not have a written agreement. He heavily relied on a translated WhatsApp conversation to prove that there was an agreement. In this case, the WhatsApp conversation was itself in Mandarin. The Sessions Court, taking into account all of the evidence, allowed Wong's claim. So Lim, dissatisfied with that, appealed to the High Court, and his appeal was dismissed. The High Court accepted the translated WhatsApp conversation as direct evidence of the friendly loan agreement, and that going by the evidence in that case, there was no evidence of the purported advancement. So let us begin with the very first hurdle to a friendly loan, and that is the legality of a friendly loan. The straightforward answer is yes, they are. A friendly loan is legal and recognizable in Malaysian law. They find their basis in contract law, but the most important issue in relation to its legality is that it must be distinguished from a transaction done in the course of a money lending business. This is because in Malaysia, you can only offer money lending services if you are licensed under the Money Lenders Act 1951. Section 5 is currently on the screen. I'll read it. No person shall carry on or advertise or announce himself or hold himself out in any way as carry on or advertise or announce himself or hold himself out in any way as carrying on the business of money lending unless he is licensed under this act. In section 2, there are definitions given. This will be in the next slide. Section 2 provides for various definitions. The word licensee refers to any moneylender to whom a license has been issued under Section 5B of the same Act. And a moneylender means any person who carries on or advertises or announces himself or holds himself out in any way as carrying on the business of money lending, whether or not he carries on any other business. The point of the second provision, of the second definition, simply explains that you need not be exclusively a money lending business. As long as you're held to be found in a money lending business, the court will consider you a money lender, even though you may be providing other services as well. There are various factors that the courts would consider in determining whether or not a friendly loan was given out in the course of a money lending business. Amongst them, whether or not the lender to a friendly loan had offered loans to other persons, or by elaborating on that, whether or not to the same person in that same agreement, he may have given more than one transaction. That's also a relevant consideration. Another factor would be whether or not the interest rate, most importantly, the late payment interest, is exorbitant, and whether or not the loan itself was friendly in nature, taking into account the nature of the relationship between the lender and the borrower, the purposes of the loan, etc. If I were to use the scenario I gave between me and my friend James earlier, if it was just a one-off transaction, me borrowing my friend James 10,000 ringgit, no problem. Let me change the scenario a little bit. Let's say I have, over the course of 2 years, offered my friend James loans of 10,000 ringgit at least 3 times. And each time I say, I'll lend you 10,000 ringgit, but in return, you must pay me back 12,000 ringgit. I do it over and over again, 3 times. And let's say I were to have given other people in my stratosphere, regardless of who they are, similar deals and a similar number of transactions. That lends suspicion to whether or not I am engaged in the money lending business. So let's look at the next slide for a case. We had mentioned earlier before the case of the Tan Ike Tech. Now, to refresh everyone's memory, the lender plaintiff Tang borrowed about 1 million ringgit, but he did not put this agreement in writing. Tan later sued to recover the loan amount. Tan admitted that he had received the monies but denied that it was a friendly loan. Tan also contended that he was not under any obligation to pay Tang back the money, as there was no loan extended by Tang and he and Tang were not friends. So these were some of the issues. In the next slide, we talk about, it was in fact suggested by Tan, the borrower of the money, that the loan was itself for a completely different purpose, i.e. that Tang needed money to buy some company shares and the defendant offered shares as security for the said loan. This was what was presented by the borrower and the court, and this arrangement was supposedly arranged by a third party, Tang's brother-in-law Goh Waika, and who is also an employee of Tan. Now, if it sounds confusing, this is simply why you should, very importantly, have a written agreement, because it is in fact this exact confusion that was the crux of the dispute in this case in both. So if I could move on to the next slide. The High Court in this case allowed Tang's claim. And so Tan, dissatisfied with it, appealed to the Court of Appeal. And the Court of Appeal dismissed Tan, the borrower's appeal, with cause. Well, let's examine some relevant passages from this particular case. This is one of them. And this is in relation to the fact that there was no agreement in writing. In Tan's case, the court had said as follows: the plaintiff admitted that there was no loan agreement in respect of the loan given to the defendant. The loan could only be proved by the 2 checks which were paid into the defendant's account, and also the admission by the defendant that he had put the money into his account. Since the defendant had admitted that he had received the 2 checks and had credited them into his account, the plaintiff had discharged his burden that the money was a loan unless proven otherwise by the defendant. As such, the burden was on the defendant to prove that the money given to him by the plaintiff was not a friendly loan. The court now tackles this issue about this thing by Tang about them not being friends. The court had said as follows: in my view, the defendant had been wrongly advised by his solicitors that in order to qualify for a friendly loan, the loan must be between friends. In my view, a friendly loan is a loan given by the lender to the borrower based on mutual trust, whereby the borrower was to repay the loan within the specified with no interest charged. This was another objection in this case, was that the borrower Tan claimed that there was simply no reason for this to have been a friendly loan. He was far wealthier apparently compared to Tang, the one who supposedly lent him the money. And this is what the court had to say. Although the defendant claimed that he was a very rich man with millions to his credit, While the plaintiff was a poor man with no means, he admitted receiving the loan amount from the plaintiff and banking it into his account. It did not matter whether the defendant was a millionaire and the plaintiff a pauper. The undisputed fact remained that the plaintiff did issue 2 checks amounting to the amount claimed to be the loan, and the defendant admitted receiving those checks and banking them into his account. It was for the defendant to explain to the court what that money was for if it was not a friendly loan. Now, I mentioned earlier that the borrower in this case attempted to try and spin a different story to get, which the court later found was nothing more than a story. I'll read out that relevant part. The plaintiff in his evidence stated that sometime in January 2020, January 2000, his brother-in-law Goh Waika came to see him and asked the plaintiff whether the plaintiff could give a friendly loan to his boss, the defendant. Now, just for clarity's sake here, Tan is the defendant and he is the borrower of the money and he is Goh Waika's boss. Tang is the plaintiff. He is the lender of the money and he's Goh's brother-in-law. So I'll continue reading. The said Goh Waika told the plaintiff that the defendant needed the loan in order to purchase Tenko Berhad shares. At the time, the said Goh Waika was working with the defendant at Tenko Berhad as his managing director. The said Goh Waika told him that the defendant offered shares as security of the said loan. The plaintiff believed his brother-in-law and gave the 2 checks to the defendant, even though the defendant did not deposit the shares to him as security. Now, the gist of it is that Tan later suggested in this case that this friendly loan was not something between him and Tang, but it was something between him and Goh. Now, as convoluted as that sounds, the court, after examining the evidence, did not find that the story was supported. In the next slide, it is explained further. So the court looked at it and said, taking the evidence in totality, it is clear to me that the evidence of the defendant and his sister that the money stated in the 2 checks belonged to Goh and not the plaintiff could not be true. This evidence was made up in order to avoid paying the friendly loan given by the plaintiff. If it is true, then the defendant could have easily brought in Goh into the action as a third party. The defendant did not do so because Goh had nothing to do with the amount in respect of the loan. The alleged borrowing by Goh and selling of shares and requesting the proceeds to be kept by the defendant was totally different and alien to the present action. Now, I imagine some of you may be confused by the facts of this case, but there are some takeaways that could be taken from this case. I set out those takeaways in my next slide. A friendly loan does not actually require the parties to actually be friends. It can be between acquaintances, it can be between family members. The point is that the nature itself is friendly, it's casual. And whatever the arrangement, so long as a friendly loan is itself enforceable and has its basis in contract law, it is basically a contract. The next point is that the absence of a written agreement, while undeniably safer to have, is not on its own fatal. In Tan's case earlier, there was no written agreement, but the court did not automatically find that there was no agreement in place. The court considers the facts. The third takeaway is that the burden is on the lender to prove that the transaction itself was a loan. Once that burden is discharged, the burden then shifts onto the borrower to prove that the money given to him was not a friendly loan, and therefore the borrower has to explain what the money was for. Let's look at the consequences of what would happen if, say, a friendly loan was to be found as a transaction given in the course of an unlicensed money lending business. First, the agreement itself would be deemed void in law. And second, the lender would be deemed to have committed a criminal offense. Now, according to Section 15 of the Money Lenders Act 1951, which is in my next slide, it states as follows: no money lending agreement in respect of money lent after the coming of the force of this act by an unlicensed money lender shall be enforceable. So, any money lending agreement that is by an unlicensed money lender is not enforceable. Now, let's talk about what will happen if an agreement is void. Quite apart from all the other terms that one would place with a friendly loan agreement, the loan amount itself would need to be paid, whereas the other terms would be unenforceable. The reason the loan amount would have to be paid is because of Section 66 of the Contracts Act 1950, which states, when an agreement is discovered to be void or when a contract becomes void, any person who has received any advantage under the agreement or contract is bound to restore it or to make compensation for it to the person from whom he received it. Now, this issue was in fact considered in the case of Mohd against Yaakob Madhim. Now, in this case, the defendant, Yaakob Madhim, was a lawyer who received the loan from the plaintiff, Mohd. Now, the defendant, in consideration of the loan sum, had agreed in writing to repay the plaintiff before a certain date and for the following sums. The loan sum of 150,000 ringgit, the sum of about 33,000 ringgit as legal fees, costs, and incidental charges, and a further sum of 196,000 being the sum by the defendant to be then outstanding by one Jamal bin Hussein. Now, this is a completely separate person, someone else. It's just part of the agreement between Mohd and Yaakob. Now, there were two issues before the court. The first question was whether or not the plaintiff had lent money on one or two occasions to the defendant in consideration of a larger sum being paid. And two, whether or not he was a money lender at the time of the impute transaction or transactions. The point that the defendant Yaakob wishes to test in this case was that this was an unlicensed money lender transaction. So let us see what the court had to say about these points. The court, in fact, allowed Mohib's claim and held as follows. Thus, if the lender adduces prima facie evidence that at the material time of the transaction, he was not a money lender, the borrower clearly had two essential factual requirements to hurdle in his cause. Namely, the loan was a money lending transaction. This is the first hurdle. The second hurdle is that the lender was carrying the business of money lender. In the next slide, I reproduce other parts for this particular case. I read the second paragraph. This has to do with the facts of this particular case. It is common ground that the plaintiff had not charged interest on the loan of 150,000 ringgit, and the 10% per annum interest was only in respect of default or late payment interest. In my view, where a loan-bearing interest would constitute a money lending transaction, I would hold that the charging of only late payment interest on a loan ought not to constitute a money lending transaction within the purview of Section 3. As obviously, no lender would carry on a feasible or viable business of money lending if he only charges late payment interest. So these are one of the factors that this court had considered in whether or not one was in a money lending business, and that was the application of interest. In the next slide, we consider further passages. Should I be wrong on the first hurdle, the question then to be determined would be a question of fact, whether or not the transaction or transactions carried out by the money lender are such as to bring within the meaning of the words carrying on the business of money lending, such as to make him a money lender as whom the act was designed to strike at. The point of this passage is simply that whether or not one engages in money lending has to do with the facts. Everything has to be considered within its own context. It's important for the courts to consider the circumstances around it as opposed to just certain facts. It has to look at everything in totality. I now move on to the next slide. In any event, even if the defendant failed in both the above hurdles, since it is only contended by the defendant by the money lending transaction is or are void rather than illegal, Section 66 of the Contracts Act 1950 requires the defendant to refund the sum received. It requires him to refund the sum. The reason being that Section 15 of the Money Lenders Act does not negate Section 66 of the Contracts Act. Section 15 only states that a loan contract in violation of the Act is unenforceable. This is axiomatic, as a void contract is unenforceable. It must be noted that as such, a loan contract is a void but not an illegal contract. Section 66 should be applicable considering that Section 66 is a specific provision to cater to an agreement which is discovered to be void or when a contract becomes void. Now let's consider the takeaways from this particular case. Firstly, one or two money lending transactions, even if considered in consideration of a larger sum, does not necessarily make the lender a money lender. One of the arguments made by the defendant in Mohd was that the transactions you saw earlier, the three transactions, he had attempted to make the point to the court that one, the agreement between him and the plaintiff was one for a larger sum. Two, that because there were more than one or two money lending transactions, when taken this into totality, he argued that this was an unlicensed money lending business, which the court did not agree with, because the court will consider the facts surrounding the loan to determine whether a friendly loan is a money lending transaction. And even if the friendly loan is found to be an unlicensed money lending transaction, the loan amount would need to be repaid. Though, of course, the terms in relation to, say, security or third-party guarantees, all of those would be unenforceable. So there's a balance to be struck between what is unenforceable and what is void. Now, the last point to be made is the criminal offense attributed to if there was undertaken an unlicensed money lending business. So I read section 5(2) of the Moneylenders Act 1951. Any person who carries on or advertises or announces himself or holds himself out in any way as carrying on the business of money lending without a valid license, or who continues to carry in such business after his license has expired or been suspended or revoked, shall be guilty of an offence under this act and shall be liable to a fine of not less than 250,000 ringgit, but not more than 1 million ringgit, or to imprisonment for a term. Could you please go back to the slide before? Or to imprisonment for a term not exceeding 5 years, or to both. And in the case of a second or subsequent offence, shall also be liable to whipping in addition to such punishment. The simple conclusions to be drawn from this issue about the legality of friendly loans is that if it is one-off, you and one other, a single transaction, it's unlikely to be held to be a money lending transaction. What is important to avoid is that the person is not being seen offering a number of loans to the same person or to many others with large interest to be recouped, and that person has no license. If not, the person would be guilty of the offence and may face the punishment as stated under section 5(2) of the Moneylenders Act. Now, that would complete my portion of this webinar. I'll now pass the floor to my colleague, Hannah, to speak on other issues in relation to friendly loan agreements. I leave it to you now, Hannah.
Hello, everyone. Thank you, Jeremy, for your really detailed explanations as to what constitutes a friendly loan and what does not fall under a friendly loan, and what are the distinctions between a friendly loan and a money lending business. So I hope that's been clear for everyone. And if you have any doubts at all, please feel free to ask your questions in the Q&A box. I will now continue on the details, the nitty-gritty of friendly loans agreement. Now, it is always advisable, as you can tell from the cases that Jeremy has presented, that parties should have a written friendly loan agreement. You can engage a lawyer if you want to, but by and large, there are certain terms that needs to be included. And if you are happy to draft them on your own, you can. We lawyers would always look at agreements that were badly drafted and always wish that before you come to this stage, you should have gotten someone to help with very simple drafting of the agreement. It doesn't have to be a complicated document. It will be a document that can be understood by both parties. So what is the benefit of having a written agreement? The most obvious one would be that you have clear and defined terms of repayment, for example, termination, dispute resolution. These are things that I will deal with later on. But that is one of the most, if not the only important reason to have a written agreement, because otherwise you become muddled, the facts become muddled, and you have to go the extra mile to prove that your agreement is a friendly loan agreement and that you are entitled to repayment or interest even. So there will be a mechanism in place in the event of dispute. There will be evidence, if you have it in writing, that the loan isn't simply a gift. And as I've mentioned earlier, agreement doesn't have to be a complex document, doesn't have to be like a 10, 20 pages document. It can be a very simple 2-3 pages in languages that layperson should be able to understand, right? And sometimes the simpler, the better. And a lawyer can help you with finding the terms that you have in mind. And the discussion will always be three-way between the borrower, the lender, and the lawyer. So these are some examples of terms that you have to include, or what we think is important to include in an agreement. First of all would be the parties. Who is lending to who? Is it to an individual? Is it to a company? It's very important to define these roles. Next would be the repayment of these debts. It is always desirable if you have a
proper schedule, like a table of a monthly payment. For example, like for a loan of 50,000 ringgit, monthly equal installments of 5,000 every month at the 14th of every month for the next 10 months. Something like that, 1 or 2 sentences, just to set out the timing, the amount, and the duration, the period of the entire payment period. How to pay, method of payment should be set out as well, by check, by direct transfer. If you want to be detailed, you can. Bank account details. If you want these monies to be deposited into a specific account, these are things you can also include. Default. Default clause would be the clause that will kick into operation when there is a non-payment of the installments, for example. So in a default clause, usually you include the consequence of non-payment. Okay, in easier terms. For example, if your debt is 50,000, only half is paid. And what will happen to the half? Will the entire sum will be immediately due and payable? Will the contract be terminated? This is something, again, parties can talk about and discuss when drafting the agreement. So we have dealt with parties, repayment, and default. We now look at 2 other terms. Termination. Termination is a clause that I actually see often it's missing. The first 3, the parties, the repayment, and default, are terms that I usually see people include when they do draft a written loan agreement. But termination is something that's because they don't understand, the parties don't understand the effect of a termination and how a termination is done, it is not often included in the loan agreement. So this termination clause will spell out the certain circumstances under which the contract can be terminated. And there is also, in other standard form contracts for other kinds of matters, for example, construction contracts, they will have notification periods, time limits for the parties who wish to terminate to its intention to terminate a contract. Now, you don't have to, again, make it very complex. It can be a simple letter to say, person A, I no longer wish to be bound by this contract due to the circumstances that you have set out in our contract. So it can be something as simple as that. The dispute resolution clause is also very important because this will later be useful when there is a dispute already, things have turned sour, and you need a clear system or mechanism on how to resolve the issues. Mediation is usually the first step, mediation or settlement negotiation. You can either mediate amongst yourself or get in a third party. If all else fails, if the negotiation didn't work, if the settlement didn't work, you then go to litigation or arbitration. And then you also have, this clause will then also deal with what law applies. Okay, so it is implied that if parties are all in Malaysia, everyone is in Malaysia, the dispute is in Malaysia, then contracts law apply. But what if your other party is from another country? What if this contract, while the parties are Malaysian, but was signed overseas? These are certain details sometimes, just including that the choice of law is Malaysian law will make things so much easier. Because no matter the circumstances, you will come back to Malaysia and say, hey, this contract says Malaysian law shall apply. And these are things that parties have agreed to. Therefore, we will litigate this matter under Malaysian law. So that's the benefit of having the dispute resolution clause. I now invite all of you to take part in this one poll. If my colleague, Natasha, can you just launch the poll? This is the poll, question 1. Can interest be imposed in a friendly loan agreement? And if yes, what is the reasonable rate? So as the poll still goes on, I can just generally see what everybody's thoughts are on interest. I can see that most of you agree that late payment interest can be imposed in a friendly loan. And if so, 5% seems to be the reasonable rate. Okay, you can keep your responses coming, but I will continue with my presentation. The answer is yes, late payment interest can be imposed or included in the contract as long as it's reasonable and, most importantly, agreed between both parties. So you cannot suddenly during the demand comes, says, oh, by the way, late payment interest applies. No, it has to be something that you have agreed at the contract stage when there's nothing, no dispute. Right. And what is the reasonable rate? There is no hard and fast rule. And what I will be showing you later on is really just a guide. It's not a must, but I will tell you what is the preferred percentage that the court has allowed. Okay, so the reasonable rate, according to the Money Lenders Act, although Money Lenders Act does not apply in a loan agreement, a friendly loan agreement, what I wanted to point out is that these percentages are allowed by the Act in a normal money lending business, 12 to or 18% per annum. In the case of meta construction, however, now this is a normal friendly loan situation. The court held that it had the power to strike down interest element in a friendly loan transaction if the interest is exorbitant, excessive, and unconscionable. So in that case, the agreed rate was actually 8.8% per annum, but the court decided to reduce it to 5% per annum. So that's something you want to take note of, that despite the agreement of parties, court still felt that it was exorbitant, excessive, and unconscionable, and therefore had reduced the amount from 8.8 to 5%. That's one example. The other example I can offer you is if you want to follow the bank FD rates. These are some of the screenshots I've taken from 3 different banks on the current FD rates rather. Yeah, so you can try 3% if there is something more palatable to the parties. Okay, now how do you secure your loan? Okay, because a friendly loan is an unsecured loan. You're not the bank, you are not a money lender, but you're just agreed, like between friends, you are just providing a certain amount of money to another person. Now, here are some of the examples. You can ask for guarantees from the borrower. You can have individual or corporate guarantors as part of the scheme. We have seen this in examples of contracts that have come our way. You can try lien holders caveat. Lien holders caveat is quite a special arrangement under the National Land Code, where the person who owns the land deposit the title with the lender. But this doesn't mean that the lender can straight away, this is my land after there is a breach of this contract. What happens is that to enforce the right over the land, the person who holds the title will then register with a land office something called a lien holders caveat. And then you must go to court, get a judgment, and then have the land sold under an order for sale. It is quite a set procedure. And this is something, again, if your borrower has land to give as security, this is something parties can talk about and see if they are willing. Another example would be company share. So if you hold certain shares in a company and you want to give it as security, you can do it. This is what we have seen in this case, Gan Eng San and Alliance Investment Bank. The borrower pledged 51% of his shareholding in a company to the lender. Now, the mechanics of this, right? I highly suggest you hire a corporate lawyer who is able to look through the company documents, the articles of association, to check the regulators, basically do its due diligence for you to be able to have this as part of your security. There are probably resolutions to pass or charges to be created. It really depends on what you are willing to negotiate when you draft this up. You can also get third-party guarantees. You can get guarantees from directors. This was also seen in the case of Gan Eng San and Alliance Investment Bank. We've also seen in our own cases where the director is made to sign a personal guarantee for the company's debt. Let me just emphasize, there are no fixed rules, no fixed terms, as long as it complies with the law and the company structure. So now, if the relationship has gone sour, you are not being paid the amount that you were supposed to be paid, what happens? You now go for recovery. So recovery simply means you're trying to recover the debt together with interest against the debtor. The first step, even before you consult a lawyer, or when you first start to consult a lawyer, the first thing that the lawyers will ask is, can you show me the agreement if you have any? Then they will look at the relationship between the lender and borrower. Are they friends? Are they siblings? Are they family members? Was it a gift? Was it a loan? That's something that, evidence will show. What if there isn't a written agreement? We know that it's not fatal. I've emphasized that it's important that you have one, but if you don't have one, don't worry, you can still prove your case to the court that there was a friendly loan, okay, by all this evidence. As you have seen earlier, WhatsApp messages that were translated from Mandarin can be used, emails, letters. Were there witnesses who observed, who watched what happened, who was in the know? Sometimes when you borrow from people, surely you're not the only one who knows about this. Does your family member knows about it? Your friends, your colleagues? These are people who can be called as witnesses to give evidence to say that, hey, yes, this money was given. Are there photos? Are there videos of any discussion? So oral agreements. Now, even if all of this didn't happen, you don't have anything in writing, there are no witnesses, and there are no photos or videos. All you have is person A saying something to person B, and it's just your word against mine. Can oral agreement be admitted into court? The answer is yes. The Contracts Act has given a provision that says, there is a provision in the Contracts Act that says a verbal contract may be valid and enforceable so long as it has all the requirements of a valid contract as required under law. As long as there is an intention to enter into a contract, there is a consideration, there are several elements of a contract that you have to prove to say that, yes, there was an oral agreement, therefore this is a friendly agreement. How do you then go about claiming against a debtor? So earlier I mentioned the dispute resolution and choice of law clause. Now, this is when these clauses will shine and will greatly, tremendously help you and your lawyers to go about doing, what it has to be done. Okay. First of all, however, before you even go into claiming, you look at the limitation. For a monetary debt, you have 6 years from the due date of payment. For example, the installment number 2 is due on 1st January. Installment number 3 is due on 1st February. So the 6 years will be counted from in tranches. So 6 years for the first part of the debt, and then 6 years from 1st February for the second part of the debt. How you calculate and how you divide is something that we can work out. For example, if it's due on the 1st of February and he does not pay, that amount becomes roll over to the second month, for example. You can, in that instance, restart the time on 1st of February. So all these mechanics, right, should be in your contract so that it'll be easier for you to claim from the last due date, which is so that you don't have to have half of your claim out of time and then half of your claim within time. So this is something you also want to be sure of when you draft your agreement. However, that being said, let me just again emphasize, despite it not being spelled out one by one in your agreement, there are ways we can do to restart the calculation of the limitation. But you have to keep in mind 6 years from the earliest possible due date is the best time for you to come and start your recovery action. Even if you don't go to court, you can issue a demand first. So your action on issuing a demand, on pursuing the debt that is due to you is also very important. It's equally important. Okay, so sitting on your rights will not do you any good. The next thing to probably consider also the location of the debtor. Is this person in Malaysia? Is this person in outside of the country? So this may help in your decision making as to where to pursue the action. Do you want to pursue in KL? Do you want to pursue in Johor? Things like that. Now that you have decided to go to court, in case your negotiation doesn't work, you have two options. If your dispute resolution clause has court and arbitration, let's now look at court. The court proceedings are governed by the Rules of Court 2012. And there is a mechanism under the Rules of Court where you don't have to go for trial. All you need to do, if it's a simple, straightforward case of saying this person A or person B and person B admits that there is an amount to pay, you can get something called a summary judgment. And usually these can be disposed within 9 months. The most conservative is 9 months. Actually, you can sometimes get it even earlier, 6 months maybe. So summary proceedings is something where you can get a judgment against the defendant, the debtor, even without going to trial. Now, here is a list of the monetary jurisdiction. This simply means which court can you file your matter in for the specific debt you have. So if it's under 5K, you go to the small claims court, and then you can see the limitation there for magistrates, sessions, and high court. Now, I put an asterisk in the small claims court here simply because I need to highlight that for small claims court, usually lawyers are not allowed to represent anyone there. So people who go to small claims court will have to be self-represented. But if you want to be advised on, how to do things separately, you can engage a lawyer, but this lawyer cannot appear on your behalf in the small claims court if you're an individual. Now, arbitration is governed by the Arbitration Act 2005. Again, parties must agree beforehand. This one, parties must expressly agree in your agreement. For court, even if you don't, you can still use the court system. But arbitration, you must specifically agree to it. In fact, if you go for court, if you have an arbitration clause, the court proceedings will have to be suspended and then go for arbitration. So the arbitration clause is something that is powerful. Your proceedings are private. Nobody will know about it. Court proceedings is public proceedings. So that is something you may want to consider. In terms of cost, arbitration will be higher than court. So that's just a little comparison between court and arbitration. And if, again, your matter is very straightforward, you can consider fast-track arbitration, which takes no longer than 180 days. I will very quickly go through the execution proceedings. Now, execution proceedings basically means after you have gotten your award or your judgment, what then happens to it? You can now go for different mechanism under the court for you to execute the judgment so that this debtor will pay up. Okay, your time limit is 12 years. And if you have gotten a judgment overseas, for example, your monetary judgment was obtained overseas, there is a limit as to which country. I didn't list them down here. If you look at the REJA Act, Reciprocal Enforcement of Judgment Act, there is a list of countries where if your judgment was obtained from these countries, you can come and register here in Malaysia and then enforce the judgment. So this is why it's important for you to know where your debtor is. An arbitration award is something where you can register after you've gotten your award, you register to the High Court, and then at the High Court, you can then also execute your judgment. These are two examples of execution proceedings. Garnishee proceedings is where you garnish the bank accounts of your debtors. where basically it means you institute or start a proceedings against the bank saying, hey bank, I have a judgment here against this person who has an account in your bank. Please earmark that amount. And then if everything is all in order, this amount will be directly released to you without the debtor. The debtor cannot, or rather it's too late for the debtor to do anything to stop that from happening unless there is some wrong procedure or there is something wrong with your procedure beforehand. But by and large, it's a system where it's a procedure where you can get the amount from the bank, and it's only effective if you know the balance, or if you know this debtor is financially active, rather the account is active, or if there are amounts coming in from their businesses, for example. There are ways for you to find out this balance. If you are friends, you should be able to know if your friend is someone who has good financial standing. And if so, you can go for a garnishee proceedings. Now, if you are completely clueless and you don't know, you can engage third-party private agencies for you to help find out. But even then, right, it's a risk sometimes to do this if you don't know. So only go for these proceedings if you know the financial standing of the debtor. The next would be the judgment debtor summons. You summon the individuals, the directors of a company or personal guarantors to basically answer to the court on their financial standing. And then the court will set out an installment or payment scheme or some sort of arrangement for recovery. Now, in the event this person doesn't appear in court, the court can, under certain circumstances, issue an order for arrest against the individuals. Next thing would be writ of seizure and sale. This is where you can seize properties or assets if you know your debtor has a lot of assets. Can be immovable or movable properties. So if your debtor is a company with a lot of heavy machineries, you can commence writ of seizure and sale against these companies. Finally, this is not an execution proceeding, but these are more insolvency proceedings. You can wind the company up if your debtor is a company, or bankruptcy proceedings against individuals. The thresholds are 100,000 and 50,000 respectively. For bankruptcy proceedings, it cannot be brought against social guarantors. For example, one most famous example would be my father guarantees my scholarship to university, for example. He is a social guarantor, so bankruptcy proceedings cannot be brought against him. But any other guarantors, like you see earlier, and whatnot, you can bring against them, but you must ask permission from court. Leave of court is necessary. This would be the last part of my presentation. And this is something my client always asks. Will it be a paper judgment? So paper judgment simply means you have gone through the entire process and you've already succeeded on every front, but you still don't get your money. Will it be a paper judgment? Yes, sometimes. So that is something that you have to think about when you want to commence a debt recovery action. Is it worth it? Is it not? And I always advise, despite me being a litigation lawyer, I will always say litigation should be your last resort. Try other means, talk to this person, negotiate, mediate, either get a third party or anyone to just help come up with something amicable before you resort to litigation or arbitration. And finally, safeguard. You never know. One day you could be friends and the next you could be not friends anymore due to the monies that you have lent or borrowed. So always, and I think this applies both to the lender and the borrower. Both your rights should be safeguarded in an agreement, a written one, the most ideal. All right. Okay. And with that, my presentation ends. Thank you, everyone.
Thanks, Hannah. Thanks, Jeremy, for sharing everything. We now move on to the Q&A session. We are running a bit late, but I hope you can bear with us. I think I was so focused on what Hannah was presenting as well, so I didn't even check the time. So we do have our first question, and I think it's directed to Jeremy. We have the first question. How are the banks supposed to view these friendly loans The participant seems to have received queries from the banks questioning the intention for these transfers between friends. So how would you address this?
I'm considering the question. I would say that it's difficult to express how the bank should view friendly loans for the simple reason that the banks have no involvement. It is true that friendly loans are not subjected to the same qualifications and procedures which the banks or even licensed money lenders would require before a loan can be given. Friendly loans are between friends, acquaintances, etc., and they are a casual exception to the monopoly of money lending by banks and licensed money lenders. It is the case that not all in the public are fortunate enough to be given loans by such bodies, and so they turn to the general public, including families and friends. What is important, however, is that the general public, be educated on the need to, as Hannah mentioned earlier, to safeguard one's interests in friendly loans. It's always important that there is a clear written agreement with a clear repayment schedule. This is where the lawyers and the courts, they come in. The greater there is awareness of this issue and of the consequences, that there will be less consequences that would arise from friendly loan agreements.
Yeah, I guess in that case, because friendly loans, like for banks, when we get the loans from banks, they're so cautious of giving them money. They have everything in order, and bank is helping them prepare the documents. So if we're the lenders or we're involved in these friendly loans, we would have to self-regulate, right, to make sure all the documents and everything are in order, like Hannah mentioned. And the next question, I think, is also directed to you, Jeremy. The participant was wondering, what if parties initially agreed that the interest is chargeable, say at a particular rate of 2.4% per month, but then subsequently refused to pay for the same and claim that it was an unlawful loan and seek to claim that it was attributed to an unlawful money lending business?
Okay, there could be other facts. I accept that, but I guess the answer would lie in what the defaulting party says is unlawful about the transaction. As mentioned in the cases earlier, it would be harder to prove that a loan is one which is done in the course of a money lending business if it is one-off, a single transaction. But you mentioned here an interest, 2.4% a month, that would amount to roughly 28% a year. That's quite high. In the facts that's stated in the question, you don't suggest when is repayment to be made as well. So it could be rolling. So that is a relevant consideration. And I would say this rather high interest rate would be something that the court may be minded to weigh as a relevant factor in determining whether or not this is a money lending transaction. So you have on the one hand, something that appears to be a one-off transaction, but with an extremely high interest, really high interest loan. So on its own, hard to say, unless there are other facts or considerations to be considered within this factual matrix.
Thanks, Jeremy. Hannah, the next question for you is, what evidence can be shown or prepared to show that the monies are a gift to, say, a non-relative? I think you mentioned, yeah.
Yeah, okay. I think, again, there is no hard and fast rule, but I can give you some examples based on what we have read and what we know. Obviously, the relationship between these two persons, despite them not being relative, would be something that the court will look at. Are you a close friend, or are you some random acquaintance that you have not seen for 10 years and then decide to contact again? That's something the court may consider. Was there a repayment plan when you lent that money? I think this is the biggest gift away, because a gift means I give you something without expecting it to be returned to me. And if you give that money and there is no request for repayment after a number of years, and suddenly one day you decide, hey, he borrowed like 5,000 from me, and I suddenly decide, you know what, I want it back. The person who received that money will say, look, we're close friends. You have given me that 5,000 years ago, and suddenly now you want it back. The court may look at it and say, look, it was a gift at the material period of time, and you decide it being not a gift later on may work against you. So these are just a little things. So the repayment term, I think, is quite important. If there is no demand being made, if there is no request, hey, later pay me back, that kind of conversation, if it didn't happen, it's very hard for you to say that it wasn't a gift.
I see. Okay, now you're just reminding me of some of the times where I feel like I also didn't realize I was giving a gift.
It's important, sorry, Anis, it's important. This is a reminder to all of us, despite us lending money out of our goodwill, if you intend the money to be returned to you, say so clearly.
Yeah,
Mm.
that's a really good reminder. And the next question is also for you, Hannah. It's based on a scenario. If a lender intends to give out 1 million loan to 3 separate borrowers without interest, and each of these borrowers are to pay back equally for each person. So the question is, do all 3 borrowers sign one agreement, or is it one agreement between each borrower?
Okay, sorry, go on, sorry.
Because the second part is, if all 3 borrowers sign the first agreement, if one of them passes away, how will this affect the other 2 borrowers' payment obligations? Yeah.
Okay, my answer to this is it's up to you. Which one is more convenient? Which one makes more sense? There is no hard and fast rule again. If you think it's more convenient to have it on a separate agreement, go ahead. But usually what I see, if it's for one transaction, or actually even many transactions, they're usually just one agreement and all parties will sign. And if one person passed away, there should be a clause in there which deals with a survivorship, or which deals with what happens with the remaining sums that are due when one of the borrower passes away. This one, I really suggest you speak to a lawyer, because then the lawyers will be able to draft something and craft something that is customized to your situation.
Thanks, Hannah, for answering that. I think we're almost running out of time, so I will take the last question. If we haven't answered your question, please feel free to drop us a message, and we can, if you just hang tight, I'll give you some links later where you can drop us the messages. But first, one last question for you, Jeremy. What is the minimum interest rate for a money lending agreement?
So the Act itself provides an interest rate between 12 and 18%, depending on the nature of the loan. Section 17A states that for the purposes of this Act, the interest for a secured loan shall not exceed 12% per annum, and the interest for an unsecured loan shall not exceed 18% per annum. So I hope that answers your question.
All right. Thanks, Hannah. Thanks, Jeremy, for all your really good information and reminders and how we can protect our own rights. Before we conclude, allow me to make a few announcements. Please stay tuned for our upcoming talk, which will cover anti-trafficking in persons and anti-smuggling of migrants, which is known as TIPSOM, and offenses relating to smuggling of migrants. So this will be our next online talk, which will be given by our crime team. You may visit our website as shown on the screen, or you may also scan the QR code to sign up for our online talk. Please feel free to follow our social media to be updated on future talks or events hosted by our firm. We are on YouTube, Twitter, Instagram, LinkedIn, and Facebook. So you can find us there. If you would like to speak with our lawyers, as I mentioned earlier, we offer a complimentary 30-minute consultation via video conferencing or calls. So you can fill up the form on our website, or you can follow this link or scan the QR code before you, and it will take you to the form that you will need to fill up if you want to get a complimentary consultation. And lastly, thank you to all our guests and all of you who have joined us this afternoon. We hope you found today's talk informative and useful, and we hope to see you at our next talk. Thank you.